I'm Judy Scott. I'm a member of the board of directors of ACS. Thank you. And also general counsel of the Service Employees International Union and partner in James and Hoffman. So I want to thank you it's been a great evening, and I have the privilege of introducing the evening's closing speaker, Oregon Senator Jeff Merkley. Senator Merkley has spent his lifetime in public service. His entire career has been motivated by a simple philosophy that each of us has a responsibility to make the community, the nation, and the planet a better place. He is certainly the epitome of the convention theme and certainly has one of those diversity backgrounds that was described by Senator Warren. Senator Merkley led Portland's Habitat for Humanity and worked with low-income families to rebuild neighborhoods, helping scores of Oregonians purchase their first home. Elected to the state legislature in 1998, within 8 years, he was Speaker of the House. His session was described by the Oregonian, the state's largest newspaper, as Oregon's most productive in a generation. We could use a little bit of that here in the Senate, as we've heard. In 2008, Senator Merkley became the first Oregonian to defeat an incumbent U.S. Senator in over 40 years. In just his first term, he has already been a strong voice for health care reform, pushing to expand access to affordable insurance to small businesses and working families. He has emerged as a leading proponent of capturing the clean energy revolution to strengthen the American economy. And he has forcefully argued for strategies to help families at risk of losing their homes and to correct the abuses by Wall Street that led to the financial crisis. Senator Merkley was also honored to take the baton from late Senator Ted Kennedy as the lead sponsor of the Employment Non-Discrimination Act. And he has made full equal rights for gay, lesbian, bisexual, and transgender Americans a signature priority. In addition, in an area close to the hearts of so many of us here at ACS, Senator Merkley has led the charge to reform Senate rules to fix the filibuster, prevent gridlock, and fight against blocking the votes on the nominations of highly competent judges and presidential appointees, including the 5 nominees to the National Labor Relations Board, our federal labor law agency that now is at risk at shutting down in August. Just last week, Senator Merkley held his first hearing as the new chair of the Subcommittee on Economic Policy of the Senate Banking Committee, where a panel of working people and economic experts provided much-needed perspective on the state of the economy and the future of the middle class. But Senator Jeff Merkley doesn't just talk the talk, he walks the walk literally. Several years ago, this is something we at SEIU know well, in Oregon, we were the union doing home visits to child care workers who were organizing into our union. Jeff Merkley joined union members and staff for a morning orientation and then spent the entire day going door to door with SEIU organizers. Now, there aren't a lot of U.S. senators with such strong commitment to working families and their unions. So needless to say, it is with extreme great pleasure that I introduce to you a great American and a fighter for working families and, frankly, another senator you can fall in love with, Senator Jeff Merkley.
Thank you all. Thank you. Well, thank you all so much for inviting me to come join you. I am the non-lawyer here among 1,000 experts. And so basically my job is to tell you all that as you work in your various walks of life, it's up to you to change the world. You all in this room can wreak enormous differences on the experience of our nation, for our working Americans, And that is work well worth doing. Didn't Elizabeth Warren do a tremendous job? It's just, I feel like wearing one of those little wristbands, WWEWD. What would Elizabeth Warren do? She is a terrific addition to our caucus, and I know folks across America pitched in to help in the race, because essentially, with 100 senators in the U.S. Senate, every one of them are your senators, and every battle matters. And I am so pleased to have her advocacy for and understanding of the challenges that are being faced by our middle class, a middle class that's being squeezed by powerful forces, by the cost of going to college, by the collapse of home ownership, with the values dropping enormously, with the loss of living wage jobs. These are all huge factors, and she is going to be an enormous, enormous force. Now, I wanted to thank Judy so much for introducing me. Throughout her career, she has been an advocate for working people in virtually every area of labor law, from mine workers to women's rights to so on and so forth. And so, Judy, thank you for the work you do, and thank you for the introduction. Now, Judy mentioned Employment Non-Discrimination Act. And I just wanted to tell you that when I was working to recapture the House for the Democrats in Oregon, and this is something in 2003, I decided to drop my paid job, if my wife would allow me, and basically take on the job of trying to take back the Oregon House, because we had a Democratic Senate, a Democratic governor, and we had a House that blocked everything. So our Governor Kitzhaber, who is now governor again, was known as Dr. No. But now, with a Democratic House and a Democratic Senate, he's known as Dr. Yes. This is a good change. Well, one of the battles when I became Speaker, there were two things that I had said to the LGBT community: that we would fight for full domestic partnerships. We have a constitutional ban on marriage. And we would fight for full basic rights. And it was a great joy in 2007 to win both those battles and take a huge stride forward for our LGBT community. I didn't have a lot of interactions with Senator Kennedy. I talked to him about serving on his committee. I talked to him about sailing. I talked to him about health care, but he wasn't with us very long. And we didn't know each other extremely well. So when he and his team asked me and my team to take on the leadership, to carry the torch on employment non-discrimination, I was deeply, deeply honored. And I want to tell you that tonight, minutes ago, Majority Leader Harry Reid became the 50th co-sponsor of Employment Non-Discrimination Act. "17 years ago, we had a vote on employment non-discrimination. It was 49-50. We lost by one vote. One senator was absent tending to his ill son. Had he been there, we would have had 50-50, and the vice president would have voted yes, and we would have won it 17 years ago. It is about time that anywhere you go in this country, you can walk and know that you can walk in any job, and you can't be thrown out of the job or banned from getting the job in the first place because of your sexual orientation. Now, we need guardians of the law, and I know that you all are, because we have fundamental threats to our Constitution. We have fundamental threats to our democracy. Your dedication as an organization to protect and enhance the fundamental principles of human dignity, individual rights and liberties, genuine equality, and access to justice are needed now more than ever. And so I am so delighted that you all exist. So I thought I would bend your ears a little bit about a few of the big challenges we have, and this might sound a little bit like I'm echoing Elizabeth Warren, and I'm proud to do it. let's talk about secret money. Let's talk about secret law, and let's talk about a broken U.S. Senate and how to fix it. Starting with Citizens United, a 5-4 decision by the Supreme Court that allows unlimited corporate spending on campaigns. Now, think about a board of a company, a very large company. They can spend a few percent of their net profits and basically spend as much as the rest of America put together. This is no exaggeration. Take Exxon. If in the last election they had spent about 4% of their net profits, and in 2008 it would have been 3% of their net profits, they would have spent as much as the rest of America on the presidential campaign. That's the type of power concentrated into a single boardroom with a group of folks not spending their own money but spending the shareholders' money, and being allowed to do it without even disclosing to the shareholders that they're taking that action. That is a humongous force, and it's a flow of money, a flood of money, a tsunami of money that threatens to drown out the voice of America. And that is not okay, and we have to change it. I think of how President Lincoln said, and he summarized the experience of the U.S. as saying it's government of, by, and for the people. And of course our Constitution starts out, we the people. And as students of the Constitution, you've probably looked at it so many times and seen that the writers of the Constitution put those first 3 words in supersized print to remind us what this is all about. But Citizens United is government of, by, and for the powerful. It's a very different vision of our nation. So we tried to stop it in 2010 with the Disclose Act, at least to be able to say that all Americans should know who is spending money. When a tobacco company comes in and puts $1 million in my campaign because I fought to end their new strategy for addicting kids through a product that's a form of it's tobacco candy, when I want the citizens of Oregon to know that's a tobacco company that's doing that. And then I can tell them why. And then the citizens can decide whether they liked the fact that I tried to stop that product or not. And so on and so forth through other powerful organizations. We did not get cloture by 1 vote twice in 2010. 59, 61. 59, 31? 41, thank you, 59, 31. It may be that 30 years from now, we look at that missing vote twice, and the fact that we were forced to get cloture and get that 60-vote standard as a moment when our country took an enormous turn, a turn that it shouldn't take in our constitutional vision. Now, so re-pursuing the Disclose Act is one approach. A constitutional amendment is another, and there are terrific ideas put forward by Tom Udall of New Mexico and Bernie Sanders. I'm sponsoring both of them, co-sponsoring both of them. Their path is very difficult to get the supermajority needed for constitutional approach. But how about corporate disclosure? How about the principle that the owners of companies should actually get to know how the company is spending money on campaigns? That's something that's much more within reach, and we need to make it happen. Let's switch to another piece of this puzzle, the 501c4. Now, the 501c4 loophole comes from a dramatic difference between the plain language of the law and the regulation. The plain language of the law says that donations to an organization must be used exclusively for social welfare activities. Now, I thought exclusively was a fairly clear standard. Sounds like 100% standard. The IRS put in a regulation, and it says, and I went to the floor of the Senate and read the law and then read the regulation because I couldn't really believe that this was true. The regulation says the word exclusively means primarily. That's 100% standard being reduced to a 51% standard. Now you have a social welfare organization that in which the donors are shielded because it's social welfare, charitable activities. Now the donors are shielded, and you can spend the bulk, half the money on political activities. And if the IRS isn't watching, you can spend a lot more than half the money. And the IRS has not been watching. So that's where we are. Now, the IRS made a terrible, terrible mistake. No question. It's a scandal and unacceptable that there be any sort of ideological screen put forward in qualifying 501c4s. But it is also unacceptable to have this huge loophole, this Karl Rove Crossroads loophole. Now, Karl Rove and Crossroads aren't the only ones using this. There are groups on the left and there are groups on the right. They just happen to be one that really promoted it and said, we can shield your donations and use this structure. Well, how about we ask the President to cast a major act in favor of transparency and close this 501c4 loophole. From secret money to secret law. Kind of a hot topic right now. Yesterday, General Alexander, the director of the National Security Agency, was testifying in front of the Senate Appropriations Committee. I was assigned to that committee this year, and so when it became my turn, I pulled out my cell phone, I held it up, and I said, General, what were the legal grounds for the NSA to acquire my cell phone data? And that's a pretty simple question. But it takes us to the heart of the dilemma that we face with secret law. And the general said, very accommodatingly, he said he'd get back to me on that. He'd consult with his lawyers. And I appreciate that. I want him to consult and get it right. But here's what we know. We know what the plain language of the law is. If you apply for the production of tangible things, that's, as you all know, lawyer taught for getting a business record, you have to do the following, and I quote from the Act. You have to provide a statement of facts showing that there are reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation. Now, that's a lot of standards thrown in there. Reasonable grounds, tangible things, relevancy, authorized investigation. So what authorized investigation is out there that allows the vast vacuuming of all of your information on your phone calls? Well, that's a fair question, and we don't know the answer. Let's focus on this keyword, relevant. Now, if it's in the law, it has meaning. Now, it implies that you take the different business records and you say these are relevant, these are not, and you set some standard for how far removed. Is it 1 level removed? Is it 2? By the time you get to 6 points of separation, as they say, you've touched every person in the world, or in this case, every cell phone record in the world, every phone record in the world. And so the secret court has to set this standard. Now, how does the secret court do this? Well, there's a proposal made for interpretation. My understanding is it comes from the executive branch, and a judge on the secret court decides whether or not that's acceptable. But there's no advocate there to say, wait, relevancy means X, Y, and Z, and it doesn't exist. And what did we end up with? We don't know what the finding of the court was because those have not been declassified. So we don't really know what the law is, but we do know what the action or results are. And that is all phones, all the time, all across America. No sorting on the basis of relevancy. No test in the language of law. And it would be great if we could declassify the secret interpretations of the FISA court so we could actually have a conversation about what we want the law to mean. That's why I filed an amendment last December to the FISA bill calling for the AG to declassify interpretations of the law embedded in the FISA court opinions. It's why when I raised this issue, Senator Feinstein on the floor said that she supported the concept I was putting forward. She couldn't support the amendment because we had to have a bill that matched the House bill, but that she would participate, and indeed she led a letter that I joined, and Mark Udall and Ron Wyden joined, in asking the court itself, the FISA court, to declassify findings of laws in its opinion. We did get a reply. The answer was no, thank you. So it'd be too confusing. Well, maybe it's confusing to have law that we don't know what it means. And so that's why I refiled the December amendment as a bill this week, Senate Bill 1130. And I want to say we already have 12 co-sponsors for that bill. And I asked General Alexander of the NSA yesterday, I said, this concept of now taking these secret FISA interpretations and declassifying them so that we will actually know what the words of the law mean, Section 215, would you support that? Is that reasonable? And he answered. And he said, with a caveat, he said, I'm inclined to think that that's the right thing to do. I'm not quoting word for word, but approximately. He said, I've got to check with my lawyers, but I think that the principle makes sense, and I appreciate that. And indeed, in the last couple days, because I just filed this, I believe, Tuesday morning, the New York Times editorial board, the Bloomberg editorial board, John Healy of the LA Times, E.J. Dionne of the Washington Post, the American Association of Law Libraries, the Constitution Project, ACLU, Project on Government Oversight, Credo, OpenGovernment.org, have all endorsed making secret law public and passing that bill. I don't know if you all endorse. I see no. Okay. Otherwise, well, if you did endorse, would you support that? We've got to fix the broken Senate. I came to the U.S. Senate as a 19-year-old, interning for Senator Hatfield from Oregon. I had a terrific summer. I was assigned to work on the Tax Reform Act of 1976. And not only was I immersed in studying all the amendments that might be proposed that were being circulated and the opinions of folks back home in Oregon and opening the letters and drafting responses, but it came up on the floor of the Senate that summer. What a gift to a young man to now have to go to the floor of the Senate, actually the staff gallery, and watch the debate, take notes, and then, of course, we didn't have television on the floor of the Senate. We didn't have email. And so, therefore, what happened is senators saw the bells and they rushed to vote. They didn't know what it was. They would meet their staff members. They came out of the elevators and before they went on the floor, and you would give them the whole account. One time, Senator Hatfield said, I'm late. Should I vote up or down? And I was just out to explain that there were 3 levels of motion involved here, and one reversed the other, and this was the subtlety of it. And he's just like, no, up or down, yes or no. And I was like, yes. And he ran onto the floor, and I ran up to the staff gallery, and I thought, oh no, did I just ruin America and give the center bad advice? I did come to realize later that the senator undoubtedly checked in with his colleagues, so all was fine, but he did vote yes. So that Senate involved amendments coming up one after the other. There was no negotiation over amendments. It was whoever got the attention of the presiding chair. And the chair probably mixed it up because there would be 10 people yelling at once, so you'd get people front and back and left and right, one side of the aisle, the other side of the aisle. And you'd just go through amendments basically until everybody was exhausted, and then you would ask for the final permission to have a vote, and you'd get it, and you'd vote, and it was a simple majority vote. Simple majority vote. What do you know? Well, this is a little different than today. I think about the fact that when Lyndon B. Johnson was presiding officer, majority leader of the Senate, in 6 years, when he asked, everybody's spoken, let's have a final vote. How many times do you think he had to file a petition rather than just get consent to have a final simple majority vote? I heard 0. I heard 1. It's 1. 1 time in 6 years. Harry Reid, his first 6 years, had to file 391 petitions to try to get to a final vote. Now, these petitions are designed for rare use, and they take up an entire week. If you think about it this way, there's a debate on a Monday that's followed on from the previous week. And everybody's had everything to say. Nobody else has anything left. The amendments have been proposed. And there's a request to have the final vote, unanimous consent, and somebody objects. One senator objects. Now, on Tuesday, you have to get 16 senators and file your petition. But then you can't vote on that petition until Thursday. On Thursday, you have to get 60 votes, and if you get those 60 votes, you have to have an additional 30 hours of debate before you can actually have a simple majority vote. So one second objection on Monday produces a week-long delay. Now, last I checked, I don't think there were 391 weeks in a 6-year period. And you can start to see the paralysis that has developed. In the last 2 years, 24 appropriation bills, we heard exactly one on the floor of the Senate. Now, last year we had, coming out of committee, we had a bipartisan bill replacing No Child Left Behind, had strong momentum. It never got considered on the floor of the Senate because the floor of the Senate is too tied up. Now, this feeds cynicism about government not being able to solve problems. It creates the reality of government not being able to solve problems. So it's not misguided cynicism. It's realistic. That means our young folks are looking and saying, why can't we take on living wage jobs and expand them? Why can't we take on global warming in a serious way? Why can't we change other aspects of what we do in healthcare to make it work better? And so on and so forth. And they see this paralyzed body and feel a sense of hopelessness. And that's not okay. There was a time when the U.S. Senate was considered the best deliberative body in the world. And we must restore that reputation. In 2011, Tom Udall and I proceeded to try to get the Senate to move. Tom really emphasized and pursued the fact that we should have a process in January every 2 years. I was working to try to put together pieces of what that might look like. We were working together, Tom and I were. And we had 40 plus votes for a package of reforms. I think we had 46 for the talking filibuster. But we didn't change anything. And we didn't have a movement inside the caucus or outside. 2013, January comes along. And now there's a whole bunch of senators who believe that we have a responsibility to make the Senate work again. And there's a whole bunch of organizations outside that are fighting to make the Senate work again. And I hope in all your conversations with your senators from whatever state you're in, every state you're in, you will help persuade them that it's their responsibility to be part of a legislative process as envisioned under the Constitution to address these big issues facing America. But in January of this year, we didn't get the significant changes we'd hoped for. We got basically modest changes, worked out with a bipartisan group of 8, modest changes, plus a promise of comity. Now that's I-T-Y. Well, the comity didn't materialize. Within days, John McCain was filibustering, the first ever in our history filibuster of a defense secretary who just happened to be a former Republican colleague. And then we had a group of 41 senators who wrote a letter and said, no matter who's nominated for the Consumer Financial Protection Bureau, we will oppose that nominee, no matter how qualified that person is. And then there was the budget that we passed, and we're trying to send it to a conference committee. And the Republicans are filibustering, starting the conference committee with the House, as if there's some risk there. But the levels of absurdity are high. We tried to get Gina McCarthy out of committee, and Frank Lautenberg was very sick, so he couldn't be there. And so our Republican colleagues decided to walk out on the committee so there wouldn't be the necessary quorum to be able to bring out her nomination. So he came in the following week, very ill, and then our colleagues across the aisle showed up because the walkout no longer mattered, and we got her out of committee. But we need to get her. She's been, let me stress, I want to stress the absurdity of these obstructions. She has been the environmental advisor to 2 Republican governors. And we can't get her to a vote on the floor. Or Tom Perez, Secretary of Labor, nominee, incredibly qualified. And Elizabeth mentioned the National Labor Relations Board that will become completely dysfunctional if we can't get the 5 nominees confirmed. Or the D.C. Circuit Court, Caitlin Halligan, extremely qualified and rejected. And really that was a complete blow-up of the 2005 deal that was struck in which the Republicans said, they were in charge, they said, if you keep filibustering, we're going to change the rules. And so the Democrats said, no, don't change the rules. That'd be terrible. So we'll quit filibustering. Well, wouldn't it have been better to change the rule? The delays, I'm sure you've heard these many statistics. You can cut it any one of a number of ways. It was 29 days for an unopposed nominee under the Bush administration. It's basically 4 times that for Obama, 124 days. Or look at it as 14 filibusters of nominations a year for Obama, 1 per year for Reagan. You can go on and on. It is a conscious strategy to paralyze the president and pack the court, and that is unacceptable, and we have to change it. I think about how would Franklin Roosevelt have helped lead us out of the Great Depression if he couldn't have gotten people into position and he couldn't have gotten legislation voted on the floor. So what to do? Well, on the legislative side, we need to end the filibuster on the motion to proceed, straight or up and down vote, give people an hour to debate it. We need to end it on getting to conference committee. Both houses have approved a version of the same bill. Why blockade the start of negotiation to try to get a common product? We need to change the 60 votes that are required to end debate to 41 to continue debate, so those 3 to 5 senators who might be absent count for closing debate rather than for paralyzing the Senate. And if 41 senators say they want more debate, then they have to debate. They have to be there, 1 at least, on the floor of the Senate. Having 1 on the floor of the Senate speaking at all times is a pretty modest request. It's 1 of 41. And what it does is it tells the American people when they tune into C-SPAN that there's a filibuster, because right now they're invisible. We have the silent filibuster because the burden is on the majority to get 60. No one has to talk. And when those 41 decide that they have said enough, or the American people weigh in and say, you are a hero, keep going, or you are a bum, sit down, the American people will help the Senate close debate and get to a final majority vote. James Madison and Alexander Hamilton had a lot to say about this. James Madison said on the supermajority, he said, it would be no longer the majority that would rule. The power would be transferred to the minority. Were the defensive privilege limited to particular cases, an interested minority might take advantage of it to screen themselves from equitable sacrifices, or in particular emergencies to extort unreasonable indulgences. Or what did Alexander Hamilton say? He said in Federalist Paper 22, and he was speaking from his painful experiences as a New York delegate to the Articles of Confederation Congress, he said a supermajority rule results in, and I quote, tedious delays, continual negotiation, intrigue, and contemptible compromises of the public good. Well, not exactly high praise for a legislative or nomination supermajority from our founders. And indeed, Hamilton, he also went on to talk about the challenge in nomination power. He believed the nomination power should be kept with the president and not the legislative branch to avoid the party likings and dislikes, partialities and antipathies, attachments, animosities, which are felt by those who compose the assembly. Doesn't this sound familiar? And he went on to say the Senate should vet nominees based on the intrinsic merit of the candidate and the advancement of the public service. And he stated that he expected nominees to be rejected only when there were, and I quote, special and strong reasons for the refusal. It was very conscientious that the founders put into the Constitution a supermajority for treaties, and they didn't put in a supermajority for nominations or for passage of legislation. So we have a lot of work to do to put our democracy back on track. Be it Citizens United, 501c4s, secret law, fixing the broken Senate, and I should add, doing a little repair work on the House side too. It's a lot of work worth doing. And through this organization and through other organizations you belong to and through your personal conversations with legislators, you can make a big difference. Robert Kennedy came through Oregon just before I went to California and was assassinated. I was in 6th grade. I heard that he was speaking at the high school. I remember going home. My dad was a mechanic. And my dad came home from work. He was very tired. He said, let's go down to the high school and see this man running for the U.S. presidency. He said, oh, son, I'm too tired, but you can go ahead and go. I have always regretted that I did not go down to the high school and hear him. But this is what Robert Kennedy said. Each time a man stands up for an ideal, or acts to improve the lot of others, or strikes out against injustice, he sends forth a tiny ripple of hope, and crossing each other from a million different centers of energy and daring those ripples, build a current which can sweep down the mightiest walls. There are some important walls to sweep down. Let's do it. Thank you.